Hello, my name is Muhammad Mursal Salat. My matric number is 229959. I would like to present classification of business contract in Islam. What's contract? Contract literally binding or tie between two ends, or other words, is a legally binding document between at least two parties that defines and governs the rights and duties of the parties to all agreement. Essential documents in business contract. Number one, contracting parties, buyer or seller. They must be legally competent to enter into contract. The competence to transact. Islamic law measured largely by two aspects, namely bribery, ballet, and prudence, rush, as revealed in the Quran. Offer and acceptance, offer and acceptance or ijab and qabul, with reference to expression of both offer and acceptance. Islamic law of contract recognize both express contracts as well as what has been described as contract. By conduct, it proposes the making of an offer, either orally, writing, conduct, silence. Number three, subject matter. As for the subject matter of contract, both the item and the consideration, Islamic law stresses on the following matters: lawfulness, existence, deliverability, precise determination. Number four, price consideration. As for the price, Islamic law does not restrict it to a monetary price, but it may be in the form of another commodity. The Islamic prohibition against uncertainty requires that the price must be an existence undetermined at the time of the contract and cannot be fixed at later date with reference to the market price, nor can be left subject to determination by the third party. Trading contract, profit and loss sharing contract. There are four profit and loss sharing contracts, which is musharaka, mudaraba, muzara'a, musaqqa. Different payment cell. There are five types of different payment: mudaraba, bay, bitman ajil, bay, istisna, ijara, tawarruq, bay al-inna. Cash term. There are three types of cash term: bay al-sarf, bay al-salam, bay al-din. Other contracts: الرهن, كفالة, وكالة, وديعة, حوالة, إبرة. Next. Mudaraba. What's Mudaraba? A partnership for the purpose of making profit, which will be shared according to a pre-agreement provision between capital, ship al-mal, owner who provides the capital, agent, mudarib, who is expertise and deploying capital into real economic activities with an agreement. Two types of mudaraba: restricted or مطلقة, unrestricted or مقيدة. Profit and loss sharing between both parties, while loss is borne solely by the capital provider unless such a loss caused by negligence of the mudarib. Number two, musharaka. Musharaka or shirka can be defined as a form of partnership where two or more persons combine either their capital labor together to share the profits and loss with similar rights and liabilities. Two types of musharaka. Number one, shirk al-malik, non-contractual partnership. Shirk al-malik implies co-ownership and comes into existence when two or more persons happen to get joint ownership of some asset without having entered into formal partnership agreement. شركة العقد contractual partnership. شركة العقد can be considered a proper partnership because parties concerned have willingly entered into contractual agreement for joint investment and the sharing of profit and risk. Debt contracts. Debt contract is a Sharia principle that accepts the sale and purchase. بيع الدين debt contract or بيع الدين Sharia principle that accepts the sale and purchase of Sharia compliance securities and debt certificates. كفالة a guarantee provided by a person to the owner of goods who had placed or deposited his goods with a third party. حوالة. It means debt transfer. It refers to a transfer of funds debt from the debtor's account to the receiver creditor account where a commission might be charged for such a service. It is applicable to remittance. الرهن. It means collateralized borrowing. It refers an arrangement whereby a valuable asset is placed collateral for debt. Sarf. It refers to currency exchange, buying and selling foreign currencies. Wadi'a. The deposit of goods funds to another person who into owner for safekeeping currency or saving account. Qard Hasan. An interest-free loan, which is only loan permitted by Sharia principle. Wakala. A situation whereby a person authorizer nominates or appoints another person to act on his behalf to purchase something as agency. Types of sale. There are three types of sale. Valid sale. بيع صحيح is a valid if all elements together with their conditions are present. Existing sale but void due to defect. بيع فاسد. A sale is a valid element together with their conditions are present but there are some forbidden elements on it. Example: النجش selling high price, sells during Salat Jumat, selling grape to produce liquor. Void non-existence. Batil is a sale not valid. A sale not valid. One more element missing. Contract. Sales based on interest. Sales based on gambling. Sales of forbidden products. Liquor, for example, liquor, pork. Sales containing elements of uncertainty. In conclusion, contract creates legal relationship of right and duties on parties, and obligation in the contract must be fulfilled. There are three key elements for conception of contract, which contain offer, acceptance, and consideration. Agreement in contract must be accounting in Islamic Sharia, Islamic law and Sharia. That's all from me. Thank you all.